My topic is the role played by clinical guidelines in medical negligence. So unhappy patients can do two things. They can complain or they can raise a claim. So most of my topic centers around a breach of the standard of care. So medical misadventures, you call them, there are about 500,000 of them a year in hospitals. And this is from the Australian Institute of Health and Welfare data. Due to the diverse biology of patients, background, morbidity, fatigue, workload, high turnover of personnel, generally junior personnel around on weekends and nights with very thin supervision, a blame culture among the patients who said, this terrible thing has happened to me. Somebody has got to be blamed for this. Somebody has to be responsible. And doctors are at risk of becoming the second victim of litigation. Even though each doctor is indemnified, that just makes them a litigation-worthy person for the other party. So as we've gone through this is regulation of medical workplace, just to note that, things are considered because medicine is one of the professions like law. But, when lawyers have a problem with professional misconduct, they're actually judged by their peers, which are other lawyers. But in this case, things are self-regulating, like the Medical Board of Australia regulates the doctors until something goes wrong. And then when something goes wrong, it ends up that the law becomes the final arbiter of what constitutes proper conduct in a doctor. So this is my mind map showing the various components of it. Most of the time, as you can see, this is the complaint section and the criminal section. Then these are the stakeholders here, and these are the legislation that intersects with the case, with the performance. So as we can see, I had a case study of Gould and Southwestern Sydney local health district. An 8-year-old boy was playing in a canal one afternoon when a boulder crushed his thumb. On presentation, they gave him flucloxacillin after consulting with Liverpool Hospital, which is a big tertiary center. So the boy was transferred to Liverpool Hospital, had very delayed surgery, more antibiotics, and then the thumb developed gangrene and ended up being amputated. So as for the expert for the defense said that that was the proper antibiotic to be given because of this antibiotic therapeutic guidelines that were being followed, and doctors should not prescribe antibiotics upon a whim. So the judge did wonder, is this guideline? He had never heard of this antibiotic stewardship. He said, is it recent? Did it apply in 2011? Did it apply in emergency settings? Did doctors actually follow this guideline? They found that he disliked the expert witness. He was unduly dismissive of the clinical decision-making process, and he called it irrational. Now, as for the expert for the plaintiff, he felt that guidelines were just for junior doctors, and that senior doctors tended not to rely on them. And in this case, he felt that gentamicin should have been given. The judge concluded that from a common sense perspective, the guidelines were not mandatory and should be adapted to the situation. However, the Court of Appeal felt that the wrong legal test had been applied, and it was procedurally unfair as the plaintiff had not pleaded that the actions of the doctors were irrational, and the defense was not given an opportunity to answer this irrational charge. They felt it was open to the judge to prefer one opinion to another, but it would be seriously pejorative and rare to find that a practice supported by a large body of professionals to be irrational. So he felt that it did not reach what they call the exception threshold in terms of torts. The comment I can say is that, basically the expert witness for the defendant failed to explain to the judge that the antibiotic guidelines was a mandated policy guideline that the whole hospitals had to follow in order to secure accreditation. And that he couldn't tell the judge that the opinion held by the plaintiff defendant was outdated. And also because the judge and the experts were in such, different disciplines, that he assumed that the judge would understand what he was saying, but obviously he didn't. And it just makes you wonder that if the judge had actually worded his judgment somewhat differently, saying he preferred one opinion to the other instead of calling it irrational, it might not have been open to appeal. So guidelines are not new. They started, Plato mentioned it in 4th century, but it only more recently in the 1960s that it became based on research evidence. Before that, it was like beliefs, like you see this diagram here, there's hot, cold, wet, dry, water, fire, air, earth, and you try and balance these things like putting leeches on people to suck their blood and so on. So clinical practice guidelines, there are levels of evidence, which is written here, and judges actually do seem to understand that very well. And there's good evidence that they actually improve patient care. So however, there's so many guidelines around that nobody knows which one to follow. There are national, international, local, regional, even down to the individual department level. Even within the department, there may be different people following different guidelines. Now, as far as the administration is concerned, they divide policy documents into 3 types: policy, standards, and guidelines. And they consider policies and standards to be mandatory, whereas guidelines are not, right? But there are suggestions. Okay, so we're talking about the breach of duty of care. And so with respect to that, what we call the professional practice defense. So when can we engage this professional practice defense as a way to guard against liability? Okay, so it has to be something that is widely accepted. It must not be irrational, although there may be different opinions. Okay, so as you can see, the doctors think it's best practice and will protect against negligence. The administrators think that's good, if everyone would do the same thing, and there's actually more risk mitigation. And the patient's view, actually, they would think that that's what was supposed to be done to me, and if it wasn't done, then something went wrong. Now, in the legal view, guidelines actually have no legal standing. They consider it to be hearsay evidence where the author of the guideline is not available to be cross-examined. Essentially, it's that. And therefore, it's usually introduced by the experts. So the expert would then need to convince the judge that this represents the standard of care. So expert testimony is generally based on the experience and knowledge of the experts. They tend to bring up any journal articles, if there are any, and guidelines. And because guidelines are generally supported by journal articles, because it's a codification of the existing research. So as far as the credibility, what I found from the cases I looked through is that the credibility of the expert witnesses require them to be working in the field. As current experience, there was one expert that was 82 years old and had not practiced for almost 20 years, which the judge did, take note of. Specificity is important. Let's say the defendant is a hand surgeon. You would ideally want hand surgeons to be on the expert panel. They need to be calm and not drawn into argument with the opposing witness. And they'd be less credible. In one case, the judge noted that this expert witness did nothing but go from case to case, being an expert witness, which was his job. So I did a survey online of all the medical negligence cases involving the use of guidelines using these various websites. What I did find quite late in the day was actually Lexis Advance is very, very useful. If you look here, if you search medical negligence and guidelines, so they present you with a whole page full of these items, and you can see the green ones is is where medical negligence features within the case, and the blue lines are where guidelines feature within the case. And on the search page, on the search result page, you can just drag this across and it will show you the part where the guideline appears, and then you can decide for yourself whether you really want to open that document in order to read it. So that was very useful. So far I found about 26 cases. I have yet to finish going through the 160 results returned by Lexis Advance. So I might still find some more. So these are the things I found. Firstly, in the battle of the guidelines, there are very few cases actually where there were multiple guidelines in issue, and usually there's no problem with the experts deciding which guideline should be followed or is the most authoritative one. And in the interpretation of the guidelines, the judge is guided by the experts, but ultimately he can decide against the expert advice. For example, there was one expert who said that I would have waited for a CT scan before I did a lumbar puncture and gave antibiotics, and the judge decided to disagree with him, and he said the guidelines say, oh, you should give antibiotics as soon as possible, within 30 minutes. And so he decided that he wouldn't want to wait for a CT scan to be done first from the patient. So so it turns out that he's actually reading the guidelines and deciding what they mean
10 minutes
for himself. Yeah. So, and as for application of guidelines, there are a couple of cases where involve nurses and paramedics, and for these people, it was mandatory for them to follow guidelines. So any deviation whatsoever would actually place them as negligent. For most people, it's not. All right. So there was articles on whether it was a sword or a shield. And it turns out most of us think that it'll protect doctors from getting sued, but actually it turned out not to be the case. In the vast majority of cases, the plaintiffs that won were actually showed that the doctors were not following the guidelines. So particularly if it was your own hospital guidelines, the court would expect you to follow that guideline that existed within your workplace. So following the guidelines actually was found to protect defendants. And departure of the guidelines actually did result in negligence. Now, there were a couple of cases of these planned deviations from the guidelines. So what happened was the guidelines said that this man is low risk for colorectal cancer and only required a sigmoidoscopy. But the surgeon had actually planned to do a colonoscopy, a more extensive examination of his colon. But what happened was he left, he was a locum, and then there was poor handover of his intentions, and as a result, the examination wasn't done, and it turned out that they did not detect his cancer. All right? So they did find them to be negligent, even though according to the guideline, he didn't need more than a sigmoidoscopy. But because the doctor had already planned to do something more extensive and it wasn't done. So the other case was where the doctor actually planned to give the patient Clexane injection, blood thinner, but he failed to chart it in the medication chart, and the nurses failed to bring it to his attention or give the Clexane. But then they found that even if he had done so, he had charted it and it had been given, it would actually have made no difference to the case. And the guideline actually did not call for anything to be charted at all, did not require Clexane to be given in that situation. So he was found to be not negligent. So what we would not be able to know is what is the effect of guidelines on pre-trial conduct, because there was only one survey ever in America which surveyed attorneys and asked them whether guidelines actually influenced their decision to settle, which one quarter said it did, and one quarter said that it affected their decision whether to take the case or not. within the last 1 month, so 1/4. So it may be that knowing what I found from analyzing these cases, it may affect pre-trial behavior. Because as we know that most of these medical negligence cases are settled out of court. The problem, of course, that in Australia, it is not possible to find out this kind of information because settlements are generally confidential. And so nobody will really know why it was settled and whether the plaintiff decided to abandon their suit. So in conclusions, I can say that guidelines are seen as authoritative extrinsic evidence, a part of the expert evidence. It is important to follow the guidelines as it does offer protection, and actually it's more often used as a sword by plaintiffs. And there is a real need for a national body to endorse guidelines, revise and review guidelines. So.
Thank you. It's pretty much spot on time. Do we have questions? Before I throw my questions in. Well, one thing is more of a comment than a question. I did like some of the terminology, such as unhappy patients and adverse events. I thought it's great the way these things get described. When something goes horribly wrong and you lose a limb, and it's like, well, I was unhappy that I lost that limb. It was up there with missing the bus in the morning, and it was an event that was adverse, a suboptimal event. But that's always the case when you've got a bureaucracy trying to recast things in language. One thing I think is really interesting is that concept of secondary victimisation, where someone's indemnified. Obviously, there's professional reputation things that becoming repeatedly sued may involve. That if it's known that you're sued repeatedly and the hospital settles every time, I can understand that could be bad in terms of gossip. But I do think it's one of the things that cuts to the heart of this issue, where it's not just an actuarial process, where it's not just a case of going, well, what are you worried about? The hospital's insurer is going to cover all the costs. All we want to do is provide a solution for this aggrieved person. And I can understand why the doctors in question arc up at that response. And I know, there's often cases where it's seen that they settle, who knows why you settle. You settle for a lot of reasons. And part of it may just be to get rid of a case that's sort of damaging for the reputation of the hospital. Even if the hospital was always right, if it's like a child who's a victim or someone who's suffered a very adverse effect, there can be that issue of, well, we want to settle it because if this goes to trial and this is in the media all the time, it looks really bad even though we did nothing wrong. So yeah, I was interested in the fact that the legal process doesn't really take that into account. And that seems to be a bit of a problem for the practitioners, that you can't take your ego out of it and just say, well, it's not my money, it doesn't matter. And I had a more technical question as well. It's
like this one where it says there's no smoke without fire.
Yeah.
So even though, like I said, who in the end remembers that Dr. Patel's case was actually overturned on appeal? Nobody does.
I know Bee and I have spoken about this as well, that one of the things that it just doesn't figure in legal analysis almost at all is the fact that there is a delay between decision and appeal. And when a case is reversed, there is a period of chaos and consternation that can often be years, that affects the people who are regulated by that decision. So we study law in a very historical linear sense, and we go, well, this was the case, but then it was overturned on decision. What we don't really think about is the 2 years it took for the appeal to go through, where people who are actually in society were under the trial ruling and were saying, well, what do we do with this? This is this. How do we deal with this? And ultimately, it was wrong. But I just think that is very interesting, and I'm not sure, and I haven't really seen this discussed much in legal analysis. Anyone else got any comments?
I just think it was very, very thorough. So it was just like boom of information, as in just, wow, there is a lot in this area that I wouldn't have even sort of thought of. It was just, very thorough. So very good, Bee.
Thank you.
And there's that advantage of being able to do a deep dive on a particular area, and just to see, rather than discuss something in generalities, to be able to go, well, what actually has been the thing specifically around guidelines in these cases? Some good planning at the start of the project in setting goalposts and boundaries, I think, is really paying off in terms of how interesting the results are.